Wealth Manager here at Genus, and with me today is a few portfolio managers. Maybe you could stand. First of all, co-founder of Genus, Leslie Cliff, and 30 years ago, you were 10, but that's all right, that Genus was started. And then we have Grant Conroy, portfolio manager, and Sue Talbot, and I think, is that it today for us? So we are really honored and privileged. So at Genus, we're going to be talking about the top 5 current real estate issues facing you and your estate. And what we do with these panel of experts is it's not always us speaking, it's about what our clients do. So we focus on the investment management part and the retirement planning, but we work with all of the other advisors out there, your accountants and lawyers, to make sure that your estate's in good standing and that your taxes are being and the assets are in the right place. But today we have 2 amazing speakers, I have to say. First, we have Pam Pryor from KPMG, tax partner. And Pam is a trust and estate practitioner, as well as among other things, and the go-to person on many speaking arrangements, from Pacific Business and Law to STEP, to the Estate Planning Council of Vancouver, and many others. And then we have Alison Oxtoby, who is the founder and lawyer at Bellman's Law in Kelowna. She drove here. So I think we need to really appreciate from Kelowna to be with you this morning. Again, both of these women are amazing in their field. They are both do complicated estate planning, and we are privileged to have them here today. So I've heard them speak on this subject on a couple of things. I think it was a CPA conference, and I thought, you know, our clients will really enjoy it. And so welcome, both of you. And we are donating today because it's Giving Tuesday. So we're donating for Pam, the Pacific Alzheimer Research Foundation, and for Allison, the Inspire Health Supportive Cancer Care in their names. So thank you very much.
Awesome. Well, it's great to be here, notwithstanding the drive, which was awful, I will say. So Pam and I, as Mary Lou mentioned, got to speak together on this topic about a year ago. It was actually at a seminar for lawyers. And we had to say many, many times that there were no answers to a lot of the issues that we're raising, but that there would be soon, probably in the next year. And here we are a year later, and very few answers. But hopefully we can update you on where things are at. Where are we? I thought I would make an attempt to get away from a formal legal disclaimer that we lawyers always love. So I came up with this, but then I forgot. Pam works for big, KPMG, big accounting firm with big legal team, and of course she's not allowed to present without the formal disclaimers. So we've done both. And I know that Pam has sneakily got my my company's name in there.
I decided to cover her risk. I put Balmain's in there too. So, yeah.
All right. So now I'm just going to introduce you to Joan, and she's the star of our fact pattern today. She's 62 years old, she's widowed, she's a mother and a grandmother, and she lives in Kelowna, actually, my hometown. And she has a daughter here in Vancouver and 3 granddaughters, and she's very close to them. She spends a lot of time in Vancouver. And so she actually bought a condo here in Vancouver, which she uses purely to visit the family. So she's not renting it out or anything, it just sits there for all the time that she spends here. All right, so we're going to come back to Joan a number of times through the presentation. But we thought we'd start today with the speculation and vacancy tax, which is, of course, new, brought in last year. So lots of movement here. You'll see here, this is the a map showing the areas where the new, and so we call it the spec tax in our world. So spec tax applies in these areas. And if you look like you're maybe on one of the borders of one of these purple areas, there's actually more detailed maps on the government website. Actually, I think it goes right down to the street. So feel free to look at that if you need a little bit more detail. So the spec tax was actually designed to make housing more affordable in these areas by making it less attractive to hold vacant land or to hold residential properties as anything other than residences. To essentially just force out speculators, and in particular, non-resident speculators. It's been, I would say, quite successful. Government has indicated that they're now collecting tax on 15% of residences owned by non-residents. And last year they raised 115 million. And I think it's probably, I'm guessing most people in Vancouver, like Kelowna, would say that it's dampened the markets. You've probably heard about a number of court cases as well that have started up to challenge this tax. There's one in the works right now. I think there's 6 homeowners challenging the legislation based on right to liberty, like live where you want to live sort of thing. So we'll see where those go. So this is a list of the areas where the tax applies. You'll see we've got very generally Vancouver, Fraser Valley, Victoria, Kelowna, West Kelowna, Nanaimo. And it's really important to note that the tax applies to all owners of property in these areas, whether you live in your property or not. If you're in any of those areas, this legislation applies to you and you have to deal with it. Hopefully everybody knows that already, because you have to file an annual report each year, a declaration. And then, of course, once you've done that, you're looking for your exemption. You're looking for your out. And most of us qualify for either the principal residence exemption or the tenanted property exemption. So the overwhelming majority of people are able to, they have to make the declaration, but they don't have to pay tax. So there's 3 rates of tax that apply. Sorry, I should say there's 3 rate categories of tax, but only 2 rates you'll see, right? So the top 2 pay 0.5, and the bottom one pays 2. So I'm sure you're wondering, why do we separate the top 2 out? It is important which one of those top 2 you fit into, because different credits and exemptions will apply depending on whether you're in the first category or the second category. So the starting point is to assume that you're down here in this 2% rate category. That's the default, that everybody's in unless they can find their way into a better category. So that 2% rate is for what we call untaxed worldwide earners. So those are individuals who have higher foreign income than income that's reported in Canada. Hopefully, you can get into one of the other 2 categories. So the second one, that mid category at 0.5%, applies to Canadian citizens and permanent residents whose income reported in Canada is higher than their worldwide unreported income. And of course, the best category is BC residents. And of course, that's probably all of us in this room, I'm guessing, and much better to be there. Anybody who doesn't file, if you fail to file your declaration, you're automatically in that 2% category. So don't do that. That's the worst thing you could do. And then a final point there is that the legislation looks through trusts and corporations to the ultimate beneficial owners of the property. So we're not going to get into those. There's a lot of complicated rules about that. We won't get into them today. But if you're dealing with a corporation or a trust holding land in one of these areas, you are looking through to see who are the principal beneficiaries or owners as individuals. So you might be going up several levels even, right, through a chain of companies or companies and trusts. And so then once we know this rate, we apply it to the assessed value of the property. So that's interesting, right? A lot of different pieces of legislation we're dealing with fair market value, but here we're dealing with assessed value. So every year you take your rate, if you're stuck paying tax, you take your rate and you multiply it by the assessed value of the property, and that's your tax that you're paying. So in Joan's case, let's just say her condo in Vancouver is worth $2 million. We're going to be looking at a tax of about $10,000 per year. She's BC resident, so we'll be in that top category. 0.5% times $2 million would be about $10,000. Now she's also going to get a credit. So here are the credits available. For residents of BC, we get up to $2,000, but note that it's $2,000 across all your properties. So if you have multiple properties, it's just one, right? And so that'll shelter up to $400,000 of value. And I have seen, of course, you have to have sufficient income to get the credit. And I have seen calculations, it's quite high. I forgot to ask you, Pam, do you recall what that income is? It's pretty significant in any event. Then second group, of course, this is our mid category. If you're not BC resident, but you're not foreign either, you're a citizen or a permanent resident, you're also going to be entitled to a credit based on the amount of BC income that you earn. But note that it can't place you in a better position than you would have been had you been a BC resident. So that's sort of the cap of that credit. And finally, high rate taxpayers in that third category also are eligible for a credit equal to 20% of their BC income earned. But again, can't reduce it below what a BC resident would pay. And in both of those bottom two categories, they can carry it forward the next year, and they can also transfer it to their spouse, those credits. So once you've figured out what rate you're in, what credits you might be available to, now you're going to look at what exemptions might be available for you. And as I mentioned, most BC residents are going to be entitled to either a principal residence exemption if they're already living in the home, or to a tenanted property exemption if somebody else is living in their home. So the principal residence exemption, not surprisingly, is only available to BC residents. Makes sense? But note that the definition of principal residence is not the same as it is under the Income Tax Act. So I think many of us are familiar with that definition that's been circulating for years. Here, you simply look to where an individual resides for any period where an individual resides longest in the year. So longer than any other place that they've lived in the year. So if you've lived in, say, 3 places and one was 5 months and one was 3, hang on, my math is going to go off here. My brain. 5 months, 4 months, 3 months, then you're going to be resident in the place that you lived in for 5 months of the year. So it's frustrating that not only is it not the same definition as the Income Tax Act, it's not the same definition as under any other piece of legislation. Like there's now about 4 or 5 different definitions of principal residence in BC under the different pieces of legislation. So that's kind of frustrating, but at least here we have a simple definition. It's clear-cut. Don't have to spend a lot of time trying to figure it out. So if you're a BC resident, owner of residential property, and you live in your home, you're home free, you've got to file your declaration, but there's no tax payable. So I had down here as an example for Joan, if she, say, lived in Kelowna 7 months of the year but spent 5 months here in Vancouver, she's going to have speculation tax apply on the Vancouver condo, but it's not her principal residence. Kelowna is her principal residence because she's there longer. So if that's not you, if you're not living in your home, but somebody else is, you're going to be looking at this tenanted property exemption. So this is the second big exemption. And if somebody is living in your home other than you, you're likely exempt. You're likely going to qualify. But there are different rules that apply depending on which one of those rate categories you fall into. So in all cases, the individual has to have lived in the home for 6 months. It has to have somebody living in it for 6 months of the year. So that's enough to qualify as tenanted. If you had somebody there 6 months, 1 day, you're good. In all cases, an arm's length tenant will qualify. So somebody who's not related to you will qualify as a tenant. However, if you're one of those 4 and 3rd category people, that you have to pass a higher threshold. And they, in fact, have to have, the occupants have to be BC resident. And they have to, each of the occupants of the home has to pass an income test. They have to have income equal to 3 times greater than the fair market value of the rent. So if you take a couple, say, living in a home owned by a foreign person, they have to together have income of 6 times what the fair market value rent of that home would be. So it can be tough for non-residents to qualify. Mm-hmm. So here's like arm's length and non-arm's length. So arm's length, yes?
Does it have to be the same tenant for the 6 months?
No, does not have to be the same tenant for the 6 months. Mm-hmm. Yeah.
Do the 2 suites in my basement count?
Yes.
What
Yes.
was the question?
Can you repeat
The question, was whether the 2 suites in his basement count. Mm-hmm. And yes, 1 suite in a home will be enough to qualify the home for the exemption. Okay, so when you've got an arm's length tenant, so meaning somebody that's not closely related to you, excuse me, these require a written agreement. So you do have to have a rental agreement in place with these people. And each rental period has to be for 1 month or longer, right? So the Airbnb thing, disqualify generally, right? And it has to be the tenant's home. And so now I'm seeing people write clauses into their residential property, like tenancy agreements, to say that the tenant, warrants that it will be their principal residence, that they're not just renting it as like a place to stay when they're in Vancouver, right? It has to be their home for you to qualify. Non-arm's length tenants, so family essentially, they require just a right to occupy the place. They don't need a formal written agreement with them, but it does have to be, again, their residence. They have to be there longer than any other place in the year. Interestingly, these are both defined terms, like non-arm's length and non-arm's length and non-arm's length. And it's possible to fall outside of, like you'd think, well, if you're not arm's length, you got to be non-arm's length, right? Or vice versa. But actually, you can be neither. You can fall outside both definitions. And a good example would be where a trust owns a property and one of the beneficiaries is the resident of the property. Very tough to qualify in that situation. There's a few other relevant exemptions you might be interested in, and we'll just go through 3 of them. One is you're exempt if you're absent from your home for work or for medical reasons, but I would note that for medical reasons there's actually a prescribed form by regulation that your doctor has to fill out. But those reasons do qualify for an exemption. There's also a number of death-related exemptions, and these are actually very useful, especially in my practice. I do a lot of estates work. So the first one is that your executor or administrator of your estate is exempt for the year of death and 1 more year. And the second one is that beneficiaries are exempt the year they inherit a property. So they don't have to have a tenant in place like, day 1. They've got the rest of that year to find somebody. But I would note that it has to be like an estate. It has to be a property passing through a will. So if you've got like a home that passes through a trust, spousal trust, alter ego trust, joint partner trust, those won't qualify. There's also an exemption where a property is owned by more than one owner. In that case, and one owner dies, it's exempt for the year of death and the next year. And finally, there's an exemption where property is held in a testamentary trust for a minor, which has been set up by a parent and the parent is deceased. And then the last exemption that I would note, that I've used myself actually, is you're exempt for your year of purchase of a residence if you paid PTT or if you were PTT exempt. So in 2018, I had bought a condo, and it was something as an investment, a stupid move, I lost money, but I had been exempt from PTT because it was new construction under $750 in value. So I was exempt from PTT, and so I was also exempt from speculation tax for that year because I didn't have a tenant. So Pam and I spent some time thinking about how this tax would apply in people's estate planning. And it's not entirely clear, and this is where, as I mentioned, we were talking a year ago on the topic, and we said, oh, there will be answers soon. Still no answers, really. But a couple of big issues that we've noted. One is that it's really difficult to get an exemption if you've got a residential property owned by a trust. That's really hard. So just think about if you intend for property to be held long-term in a trust, this is something you want to consider. And that's because each beneficiary of the trust has to be resident in BC. We don't find that, or often that's not the case, right? You've got one kid moves to Alberta, Ontario, something like that. And the second issue it's difficult is that if a beneficiary of the trust occupies the home, as I mentioned before, they actually have to be arm's length to the trust. So not related, which, how often do you find that? The second issue, which we're going to talk about a little bit more later, is joint tenancies. So where you've got a child entitled to a home with a parent, we run into, and the parent really owns the property while they're living, the intent being to give it to the child or the child to distribute to their siblings on the parent's death. And that's called a PCOR, joint tenancy, by the way. It's really just completely unclear how the legislation is going to apply. And many of us have tried to get answers from the government on this unsuccessfully. The legislation seems to imply one thing, their website says another, and then the agents, when you call up or email, are all giving different answers. So we don't really have any guidance for you there. So then just to turn back to our fact pattern in relation to speculation tax, it should be clear here now that Joan is going to face speculation tax on her Vancouver condo because she spends more time in Kelowna than she does in Vancouver. But because she's a BC resident, she's going to be taxed at 0.5% per year times her assessed value, and she will also be eligible for a credit of up to $2,000. So again, if that condo is worth $2 million times 0.5, that's $10,000 a year, less hopefully the full credit of $2,000. So she would be looking at a tax of about $8,000 a year to hold that Vancouver condo in that example. And this is how I've been feeling about spec tax this past year. All right, over to Pam, who's going to talk about
Perfect, great, thanks.
the Vancouver vacant home tax.
Great, thanks, Allison. Okay, as Allison said, I'm going to talk about the Vancouver vacant home tax. So it's important to note this is completely separate from what Allison talked about. You could have a situation where you have a property subject to the spec tax as well as be subject to the Vancouver vacant home tax. So it's similar in terms of what it's designed to do. It's basically designed to address perceived inaffordability of properties in Vancouver and to stop people from holding onto properties that they're not renting. So very similar, except it applies in the city of Vancouver, but it doesn't apply to any property in the university endowment lands, so that's specifically excluded. It applies to any property that's deemed to be empty, and right now the rate is 1%. Similar to what Allison said, it's times assessed value, so it's not fair market value. It was announced last week, so this is literally hot off the presses last week that the rate's going to increase for next year. It's going up to 1.25% of assessed value, and then it's proposed that it's going to increase thereafter by 25% each year. So it'll go up to 1.56% and then 25% thereafter. So the exceptions for Vancouver vacant home tax are similar to spec tax, which is you've got a principal residence and if the property is actually rented. In order for the rental exception to apply, what you have to have is it has to be rented for at least 6 months, and each rental period has to be at least for 30 days. So similar to what Allison said, they're trying to stop the Airbnb rentals, right? You have to have a long-term tenant in the property. But a couple things that are different. You don't need to have arm's length tenants in the property, and there's no need to have a rental agreement, right? So it could be undocumented. Similarly, you actually have to file a declaration every year, so you should have filed already for this year. So another exemption, I mentioned the principal residence. So in order for it to be a principal residence, it has to be the place where you usually live and make it your home. And so when you look at that, you take a step back and you go, well, where do I put my address? So where do I tell CRA that I live for income tax purposes? Where does my mail come? Right? Where does my healthcare MSP address? What shows up there? Where's my driver's license? So you take a look at this situation and what do they use as their mailing address? That's your home and your principal residence for Vancouver vacant home tax. There is some exceptions similar to what Allison talked about. So if you've got a death situation and the property ends up being vacant because probate hasn't been applied for, that is exempt from the vacant home tax. But what's important to note is it doesn't address the situation where you've already got probate and you're waiting to deal with the property for 210 days after the grant of probate. So that period itself may be subject to the vacant home tax. It also, similar to what Allison said, it has to be a transfer through an estate. So if you've got a transfer directly to another joint tenant, wouldn't qualify for this exception. Similarly, if the property was held in a trust, so an alter ego joint partner trust, wouldn't be available for this either. So other exceptions is, what if you can't rent out the property? Because say it's in a strata and the strata says you can't rent it out. That will get you out of this tax. But it's important to note those restrictions had to be in place at the time these rules came into effect. It can't be available for new builds. That won't get you out. If you've got a property undergoing major renovations as well, there's an exception there. Similar to what Allison said, if you've got medical reasons, so somebody has to leave the property and go into a hospital or long-term care, you can get an exception, but only for up to 2 years during that time frame. And also if you have a property that's not exempt, so it's not a principal residence, but you've got somebody actually living and working in the city of Vancouver, they'll give you a limited exception for that as well, as long as you live in it for more than 180 days in the year. And lastly, again, if you buy property and you pay provincial property transfer tax, you can get an exemption from Vancouver vacant home tax for that year as well. In terms of trusts, they're not as complex in terms as compared to the spec tax and what Allison and I had to go through in terms of looking at those rules. It would be exempt if you have a beneficiary who lives there and it's their usual home, right, where they live, or if you have a beneficiary who's a tenant. So similar to an arm's length party, they have to live there for more than 30 days and for more than 6 months in that year, and it's exempt. PCOR joint tenancy arrangements that Allison talked about, again, they don't seem to cause any concerns under the vacant home tax. Instead, you look at the property itself as opposed to who actually owns it. So it's a little bit simpler in terms of dealing with that. So let's go back to Joan and our fact pattern there. Joan's going to be subject to Vancouver vacant home tax on the condo because it's not her principal residence. It's not where she usually lives. Allison said she lives in Kelowna. That's where her tax records go. That's where everything shows as her address. So if she's got her $2 million condo for this year, she's going to be subject to Vancouver vacant home tax at 1%. So adding another $20,000 to the cost of owning the condo. Now in this case, there is no credit, right? So it's just going to be a flat $20,000. And then going forward, the rate is going to increase.
So Pam,
Yeah.
we didn't talk about this before, but if Joan lived 7 months of the year in Kelowna, 5 months in Vancouver, but all her mail and her driver's license was Vancouver, like she saw Vancouver as like her home base. She just spent more time in Kelowna. My read is that she's subject to spec tax on the Vancouver home, but she would not be subject to.
Yeah, and I guess, you know, the question is, can you get a little bit cute in terms of stuff like that? Have your mail go one way, right? I think if you read it, then you might have an argument. I would think that, you know, if it got looked at a little bit closer, it probably wouldn't withstand any scrutiny, right? And we're still early. I mean, I haven't heard of anything being challenged in that either. And I also heard the situation where people are trying to, you know, rent to friends, right, for $1, right, and try to argue it's their usual place where they live as well, right?
Yeah.
So.
Can I ask one question?
Sure.
Property subject to rental restrictions.
Yeah.
If I understood you right, those restrictions must have been in place prior to the regulations coming into effect. So
Yeah.
if your strata introduced a rental restriction a year, 3 years later,
Yeah, that wouldn't exempt it.
can you repeat the question?
Oh, sorry. The question was, if your strata basically introduces a restriction today to say you can't rent to third parties, would that get you out of this tax? And the answer is no. It had to be in effect before the rules came into being. Otherwise, it's a very simple out, right?
I have one question about the exemption for a non-BC resident. Your notes say specified citizens. Can you tell me about that? For example, an Ontario Canadian taxpayer.
Yep. So that would qualify as a specified citizen.
That person could rent to a non-arm's length tenant.
Yes, they could rent to a non-arm's length tenant. That's correct. Yeah. So the tenant just has to have the right to occupy the property. They don't have to have a formal written agreement. Yeah. Yes.
What would happen in the case of a property if there's a caretaker that is hired to live on the property and the owners are not there or they're deceased and so forth? What would happen in that situation? That they're
think you'd be fine, but I think you would want to maybe update the caretaker's agreement to provide that it's their residence, it's their principal residence. Do you agree, Pam?
Well, I guess the caretaker, the question is it arm's length or non-arm's length, right? And you might argue, right? And I think what you want to do is enter into the more restrictive of the two, right? Assume that they're arm's length, and like you say, get a written agreement, and provide that that's their home. And we're assuming you're talking about spec tax, right? Yeah.
They're confusing, aren't
Yeah.
they? Yeah.
Well, no. I think it's more of a history of someone looking after a property. They live on the property, they don't live in the main house, and they've been there for 20 years, that is their residence. But if something happens to the owners of the property, those, would you be, I mean, I think there's death and all that sort of stuff that looks like it's covered for a couple of years.
So sorry, just to go back to your question, you're talking about you've got a separate caretaker property and they live there, they don't live in the main property? I mean, I'm not sure.
Property, but there's a.
Okay. Because if there's two separate properties, I don't think that's going to help you, right?
Yeah, I think you just need to make sure you have a written agreement to qualify for that non-arm's length, or sort of that
The arm's length, yeah.
exemption.
Yeah.
Yeah. Okay, so the third issue that Pam and I wanted to talk to you about today was joint tenancy, because one, I think there's just a lot of misunderstanding of what this means out there in the public, and two, there's been some new court cases in the last year that have really changed the framework. So just to back up high level, there's two ways that you can own property with somebody in BC. One is called joint tenants or joint tenancy, with a right, usually with a right of survivorship. So this would be like your typical bank account, right, where two people are on it and both people have the right to withdraw the whole amount, and when one person dies, it's there still for the other joint owner who survives. The second type of ownership that you can have is tenants in common. So this is where you've got, well, actually I've got a slide in one sec, we'll come to that in just 1 second. So my key point here though is that they're really fundamentally different, these two types of joint ownership, and that which one you choose, which one you have is really going to significantly impact on your estate plan in particular. So here's the two high-level types of joint ownership. So one is this joint tenancy, where both people have a right to the entire property. So think about that joint bank account. Both people could go in and withdraw the whole amount of the bank account. But on death, the survivor gets whatever's left. Right? The other kind of tenancy or joint ownership is tenancy in common. So here, each person has a specific interest in the property. So I might own my home with my husband 60-40, 50-50. Maybe I've got 99% and he's got 1%, but it's defined, right? And if that's the case, let's say I have 50% and I pass away first, my 50% is going to go through my estate. It's not going to go right away to him outside of my, it's not going to go outside of my will. It's going to go through the will to him. So no right of survivorship. And I would really encourage all of you to go home and just double check the title to your homes, because we find a lot of situations where it's not what people expect. And sometimes we end up having, one spouse dies and we've got to go get a grant of probate and pay probate fees to transfer half the home to the surviving owner, and that's often not what was planned. So do go home and just look at your title, and I would just say that if it's joint tenancy, it's going to say it. It's going to say as joint tenants right on your title. And if it doesn't say that, if it's silent or if it says something different, you're in that other category, and it won't automatically pass to the surviving spouse. And that's not necessarily a bad thing. You just need to understand which one you've got. So like in a blended first marriage, we're usually trying to do very generic, right? Or general. First marriage, we're usually looking at a joint tenancy. Blended family, second marriage, we're usually looking at a tenancy in common. So within that first category of joint tenancy, there's actually two types of joint tenancy. So one is this sort of classic, what we call it like a true joint tenancy, and that's where really both people own the property. Like there's really a right, like say it's parent and child, both people really have the right to take the money out. So when I say it like that, you're like, that's usually not the case with parent and child, right? This is much more common among spouses to have a true joint tenancy. And of course, upon death, the property is entirely owned by the surviving person. And I don't know if this is the right place to talk about this, but placing an adult child on title as a true joint tenant, like you're literally giving them half of the property, that's a deemed disposition for tax purposes and probably a loss of the principal residence exemption on half of the property. So a lot of people don't really think that through before they do it. In contrast, we have this other type of joint tenancy that we mentioned earlier in the presentation called a PCOR joint tenancy. And PCOR comes from the name of a very well-known case that went to the Supreme Court of Canada that really identified this as a possibility to own property jointly with someone, but where one person really retains ownership during their lifetime. So the classic example of this is parent and child. Maybe I own a property, I add my son onto title because I want it to go to him on my death, but really it's mine, right? I still paid for it, I still pay the mortgage maybe, I would get any income from it, it's mine while I'm living and it'll go to him on my death. That is a PCOR style joint tenancy. Usually, unfortunately, doing this doesn't achieve what people think it's achieving. It doesn't really pass your asset outside of your estate. So if I, go back to my example, add my son onto my home as a joint tenant and I do nothing more than that, all I've really achieved is that he will receive the title to my property on my death, but he holds it in trust for my estate. So probate fees are still payable, right? You might avoid the need to probate entirely if you have no other assets, but that's difficult to achieve. So usually, when you just add a child onto a bank account or a home and you don't go any further, you're really not giving it to them, right? You can go farther. You can take extra steps and document that that's really what you did want to do, but I find that most people don't do that. They stop at transferring the title and now we've run into trouble. So we thought it would just be helpful to look at some advantages of this type of PCOR joint tenancy and some disadvantages. And actually, I think these apply to all joint tenancies. So the advantages would be that you might avoid probate fees and executor fees if you've taken these extra steps. You might avoid delays. You might avoid the privacy issues that come up in an estate administration. You might avoid wills variation claims if you've done it properly and taken all the extra steps. And again, a note that there's a common misconception that it may avoid capital gains tax, but of course it doesn't, no matter what. But, this is the big but, this is what we really wanted to highlight for you today, a number of issues with joint tenancy. So the first one is that you've possibly got a deemed disposition of your asset, right? So if you really did intend to give it to your child, I guess it's more than a deemed disposition, it's a disposition.
Yeah. Yeah.
If I added it onto my son onto my property, and I really intended him to have half of it, then I've given him half, and I've disposed of half my property for tax purposes. And now, from that point on, if I live in it and he doesn't, we've only got half of the principal residence exemption available when I pass away or sell. So that's the second point, partial loss of the principal residence exemption. A big one is loss of control. So there have been cases where adult adds somebody from the next generation onto a property to try and save probate or whatever, and then they decide they want to sell later, and the child said nope, and the court said, yeah, you've given it away, so you can't then force that sale unless you have an agreement with the person you've added on that they will follow your instructions. So loss of control, and then the big one I wanted to talk about today was creditor claims. because there have been a number of cases in this area in the last year. So I'm going to just give you the facts really quickly. It was a mother and a son, and she had a condo worth about $800,000, and she had just one child, and they got along well. She wanted to leave everything to her child, so she added him onto title to the condo. She didn't even tell him, because to her this was very straightforward, no need to tell him. He knew he was getting it one day anyway. So he adds son on, but lo and behold, son was having some troubles at work. He had a business, and he had a lot of creditors. And the creditors did a search of his assets, and they searched the land title office, and lo and behold, they discovered him on title to this condo. So of course they put a charge on the condo. At that point, mom and son go to the court, and they're like, no, he doesn't really own it. We only have him there for estate planning purposes. And the court said, no, too bad. It's important that the world can rely on what the land title office registry says. And so they lost half of the condo there. And to me, that really highlights the risk involved in putting a child on as a joint tenant to a property. And there have been 2 cases that have followed that one in the last year, one more. So the first one was BC, another BC one, and then one in Ontario. And so they've said, it might work internally in a family to protect, against claims, but it doesn't work with the outside world. So you can think about other examples, right? Maybe son gets in a car accident and is sued, right? There's a creditor you weren't predicting. Potentially also a marriage breakdown. That, child goes through a divorce, and a departing spouse says, oh, but there's that home that he owns half of. You could be in trouble there too. So this is why we're more and more careful adding people onto title to homes. All right, over to Pam.
Okay, the next thing, foreign buyers tax. So what is it? I mean, most of you know you've got property transfer tax. It's payable when somebody buys real property and you actually transfer legal title. So on land titles, you've got the property transfer tax that's payable. Right now, it's 1% of the first 200,000. It's 2% on the next 1.8 million. Once you're over 2 million, you're at a rate of 3%. And if you've got residential property, there's an extra 5% property transfer tax on any amounts over that $3 million threshold. So property transfer tax can be a big cost. So if that wasn't bad enough, now you've got a potential extra property transfer tax applying where you've got residential property being transferred to a foreign buyer. So what's a foreign buyer? You've got 3 categories. You've got foreign nationals, foreign corps, and taxable trustees. And what are those? So let's go through that. So if you've got a foreign national, it's an individual who is not a Canadian citizen or a permanent resident of Canada. Then you'll be subject to that extra foreign buyers tax. In the case of a corporation, if that company isn't incorporated in Canada, or if it's controlled either directly or indirectly through layers by a foreign entity, you can be into this rule. And if you've got a trust owning property, if the trustee itself is a foreign entity, so i.e. a bad individual or a bad corporation, or if you've got a beneficiary who is a foreign entity, you can be offside of this as well. So what's interesting for this rule is you can have a situation where you've got an individual who resides in the US, and I've had this in my corporate groups. So they're non-resident of Canada, but they're actually a Canadian citizen. So in that case, the foreign buyers tax does not apply, even though you would think it should because they're not a resident of Canada. And conversely, you can have a situation where you have a person resident in BC for income tax purposes, but they're not a Canadian citizen or a permanent resident. So again, you can have things be subject to foreign buyers tax where you might not expect it. And if you're looking at a company, it's a concept of what is called de facto control. So you don't just look at who controls the voting shares, but you look at who actually controls the day-to-day operations of the company. In terms of foreign buyers tax, where does it apply? Here's your picture in terms of where it does. Here's the details. So any property that's residential property in these areas will be affected. This was expanded in February of last year. Before that, it just applied in Metro Vancouver, but then of course people, changed their buying patterns to go outside of Metro Vancouver, so they expanded the scope of the foreign buyers tax.
And we should just note there that it looks identical to the speculation tax, but it's not.
It's not.
Similar,
Yeah.
but not identical.
Yeah. All three of the taxes basically have different areas that they apply to, and we'll see that in a minute. Yep. So if a transaction is exempt from property transfer tax, it's also be exempt for foreign buyers tax. So one exception is if you've got a transfer to a surviving joint tenant. That's not eligible for an exemption. And then, of course, there are a bunch of transitional rules for transactions that were essentially in progress in February of 2018. So the foreign buyers tax can apply to a number of estate planning type transactions that we would look at doing. So if you transfer a residential property in the affected areas into a trust, and you've got a trustee who's not a Canadian citizen or permanent resident, you can be subject to the foreign buyers tax. So for us, we've always been concerned about, do we have a non-resident as our trustee? So we still have to be concerned about that, but also we now need to be concerned about their citizenship status. You could also have foreign buyers tax if your beneficiary is a foreign person, as I said. So beneficiary isn't actually defined for this purpose. When we look at income tax, it's really broad. Anybody who's beneficially interested in the trust is a beneficiary. So that it can include somebody who has a contingent interest. So they step in when someone else dies. And it doesn't need to be a current interest, it can be a long-term interest. So you can have somebody who won't get an interest for many years being a beneficiary. And that, it looks like, would subject us to foreign buyers tax as well. So we've got to take a look at that. What about if we transfer property into joint tenant with a foreign person? Is that going to be a problem? It will be a problem if they become a true joint tenant, as what Alison talked about, right? If it's intended that they have an interest right now. Now, what's not clear is what happens if you're in that PCOR joint tenancy situation. Should it apply if they're just holding title for the parent until the parent passes away? It's interesting because if they're found to be a trustee and they're a foreign person, then it's going to be subject to the foreign buyers tax. So a little bit of uncertainty still there in terms of how it applies.
And we should note there too, I don't know if you mentioned it already, that that tax applies on fair market value, right? Not.
Yeah, no, I didn't, but thank you. Yeah, it
not
applies on
right?
fair
That
market
one's fair
value.
market value.
Yeah.
Big difference sometimes.
Yeah.
Yeah.
Which generally is the purchase price. But interestingly enough, if you do corporate transactions, say you move property from one company to another in the course of a corporate reorg, question is, do you go out, you don't have a third party transaction, right? So you do an internal estimate of what fair market value is. So that may not be assessed value and usually isn't. Okay, so what if you find yourself subject to these taxes and now you decide you're going to rent out the property? So you've got to consider income tax as well. For income tax, there's really two pools of property. One which is personal use property, which would be a principal residence or a vacation property, like a cottage or something up at Whistler. And the other being income producing properties, so your rental property. So you've got these two buckets. So if you go in Joan's case and you decide you're going to rent out the property in Vancouver, you've got a change in use because before that it was a personal property for her personal use and now it's become income producing. So you have a deemed disposition at that point for income tax. You've got a change in use. And that would give rise to a sale or a deemed sale at fair market value. And if it wasn't her principal residence, you can have capital gains tax payable at that point in time. So and if you've got a situation where you're going, if the principal residence exemption was available for part of that to shelter that gain, there may not be some tax. But otherwise, you've got potentially tax. In BC, right now, 2019 top rate is 25% on any capital gains. Oh, sorry, I should have advanced the slide there. So if you go from personal use to income producing, you've got that change of use, as I said, and possibly capital gains. But it is possible to file an election to avoid that deemed disposition that would otherwise happen. The election is under Section 45(2) of the Income Tax Act, and you need to file that for the year in which the change happens. So if it happens in 2019, you need to file it with your 2019 tax return. Now, there is the possibility to late file this election, but it's better you file it in the year in which it happens. So similarly, if you go from income producing back to personal use, you've got a deemed disposition. There would be tax that may be payable there as well. In this case, you can file an election, but you usually file it in the year in which you ultimately sell the property down the road. You can file it early, but the latest you can file it is the year when you actually sell it off to a third party. What's important to note, if you want to make either of these elections, you should not be claiming capital cost allowance or tax depreciation on the building portion of the property.
So I think, oh, sorry.
Comic interlude. This one actually says, I find a tax lawyer being fun. I similarly find being a tax accountant a lot of fun. So,
But so on that last point, like for Joan, if she decides now she wants to avoid the speculation tax by renting out the property, I think she just don't do it. She shouldn't do it without talking to her accountant, right? That's, I think, the main point there.
yeah, exactly. So some concluding comments before we turn it over to some questions. As we said, the various taxes, they actually differ by location. So what we did here is we actually did side by side. So as Allison said, they're similar, but they're not identical across the 3 different taxes. So you got to look carefully at where your property actually is. Similarly, if you want to fit into the principal residence exemption, they're not identical, right? One is based on how many days you actually live in the property. The other one is based on where you usually live as opposed to actually spending time there. And then, of course, for income tax, it's a concept called ordinarily inhabited. And that, you can live in a property for a very short period of time and be considered to ordinarily inhabit it and be eligible for the principal residence exemption. So these new taxes, we said for Joan, I mean, there can be some significant annual and ongoing costs to holding a property. If there is no exemption, you may decide to sell the property, right? And we've seen some people look at doing that. You may choose not to acquire a second property if you were otherwise going to. And different areas, different situations, different impacts to our clients. And there is a bunch of uncertainties, as Allison said, particularly when we're dealing with trust arrangements, and we've gotten inconsistent answers, as she said. Hopefully we'll get some legislative changes coming our way. What happens in the future? I mean, the one thing that we're speculating in terms of seeing, no pun intended in terms of speculating, but it may be that beneficial interest transfers are going to be subject to tax, in particular property transfer tax. Right now we don't have that, but maybe that's coming down the pipe. What we are seeing is increased disclosures of trusts. So internationally, there's a trend towards increased disclosure. We're seeing that here in Canada as well. Federally, starting in 2021, we have to disclose information about trusts. So we have to disclose settlers, trustees, beneficiaries, and protectors. And we have to disclose all kinds of information about them. As well as here in BC, we have trust disclosures as well under the Land Ownership Transparency Act. And that's effective for May of next year. So it's going to make it more costly to using trust structures, but I don't think, and you can comment, Allison, we're going to stop seeing trusts. I mean, there's a number of non-tax reasons for using trusts. What's going to be important, though, is we advise our clients about this ongoing disclosures and make sure that they're aware that this is part of the compliance costs every year.
And one thing we didn't have up there, and we didn't include in the presentation because we have the top 5, but if there had been a 6th, what I would have added would be the new Landowner Transparency Act, which is also coming into force next year. And that's going to be a wholly separate land title system where everyone in BC has to register the true owners of property. So, won't be able to, even if it's in the name of one spouse, but it really belongs to both, of course, we'd have to have both spouses registered in that registry. Or land that's owned by a corporation, we will have to disclose there the ultimate owners of that property, kind of thing. So that's all coming soon.
Yeah, effective for May of next year. And I think it was 10%, but it increased up to 25%. So any person owning a 25% interest in a corporation is going to be subject to the disclosure.
Or just even a 25% interest in the land directly. Yeah.
Okay, questions, comments?
If a couple in Vancouver normal ownership, and they live here all the time, but they go on a vacation and they Airbnb their home while they're gone. And
If
they
it's,
do it twice a year,
yeah, if it still qualifies for the principal residence exemption, that wouldn't be an issue.
so it's not a change to the income.
No, if you just do incidental rental on a property, that wouldn't change it from an income tax point of view, right?
And then my second question is, where does one go to find out what the title of their property is?
Yeah.
So if you go back to the documents from when you purchased, you'll find it there in the report from the lawyer. I know. Yeah. It's an easy search to do, but unfortunately, it usually has to be done by like a lawyer, or a bank, or there's certain agents who can do it. But it costs less than $20, and it's worth checking for sure. Well,
Just for the search.
you can use an agent as well. I've never tried to do it directly. But
Any more questions?
Could you tell me where the best place to access the Speculation Tax Act is?
Online. Yeah, like if you just Google speculation and vacancy tax act, it'll come up pretty easily. Yeah, it's horrible. It's big, like it's really big. It's like reading the Income Tax Act. It's just.
Which, I mean, to be clear, just in, I like to do, so, But that said, the spec and vacancy tax caused Allison and I a number of days of grief because it's not very well drafted. There's a lot of uncertainties. So they need to fix it. And then, of course, you can go to the government website, right? They've got some Q&A on there as well.
I'm curious
Yeah.
if you have any thoughts on geographic spread of applicability in the future.
Meaning, is it going to get bigger? Yeah. I mean, that's a concern, right? As people's behavior changes, right?
How will affordability have?
Yeah.
That's likely where it's going.
Yes, I would say so. I mean, it's already expanded, right? I can't see that changing.
Yeah.
Like stopping.
And you also see people's behavior changing too. If you're going to be in the foreign buyers tax, which applies to residential properties, you shift and now you're buying commercial properties, which then forces their costs up, right? Yeah?
I just want to clarify one thing. If I own my condo as a principal residence, I go buy a house, but I want to keep the condo
Yeah.
and rent it as an income-producing property, will that be subject to capital gains?
Well, that gets you into the change in use. So you just file the change in use election. So you wouldn't be subject to capital gains tax now, but you would potentially down the road, depending on whether those years are eligible for the principal residence exemption. But what you want to stop doing is paying income tax on a transaction where you've got no cash to fund it, right? You want to delay the disposition to when you actually sell.
But generally speaking, like long term, like if you're going to rent that condo, say for 10 years, for most of those years, yes, that condo will be
Yeah.
subject to
And-
capital gains tax.
Yeah.
Even if it was my principal residence originally, would I be?
Wouldn't matter.
You'd be eligible for the PRE for the years in which it was your principal residence. You check the box, right? And then you can make an election. You can go up to 4 years after a change in use as being also eligible for PRE. Yeah. Yeah.
I wondered what criteria the government used to select the specific areas where the
Yeah.
tax is going to apply. Like, why is this area not included?
Yeah, good question. I'm not aware of how they chose it. I mean, a cynic might say lobbying,
I
right?
think it's lobbying, yeah.
Yeah.
I think they just looked, first of all, to the highest fair market value areas, and then it was a question of who lobbied hardest.
So why did they exclude Lake Country?
Yeah, I
Yeah.
don't know. It's a really good
Yeah.
question. Lake Country is an area just north of Kelowna. I think it's got the highest land values in BC. And I have no idea why it's excluded.
Yeah.
Vote conservative.
Pam, you commented on it a little bit with vacant homes tax, but would you be able to comment on the enforcement of these regulations?
I haven't heard anything, like what specifically do you mean? Like, is there going to be an audit after the fact?
Even the transparency one,
Yeah.
is that really enforced? Will it be really enforced?
Well, I think the intention is it will be enforced. I guess what's going to happen long term, we'll have to wait and see, right? It's still early days. Yeah, still
There
early
hasn't
days.
been really much enforcement yet.
Yeah.
But I think, yeah, very early days.
Yeah.
But we're starting to see notices go out, like on the speculation tax, saying you didn't file, right? You need to file. So, I think they're probably going a little bit soft in the first year,
Yeah.
because a lot of people didn't know,
Yeah.
but
Yeah.
we'll see.
Yeah, I mean, there obviously are penalties, and they can be significant, right? There's different penalty provisions in the different rules, but yeah, in terms of whether they're going to take a really hard stance, particularly where people don't understand. The one with the child on joint bank, like the joint property, that's the one where there's a lot of misunderstanding, right? And I think, you can correct me, there's some lawyers that think you can claim it as your principal residence, some that don't, for purposes of the spec and vacancy tax. And we found something on the website that said you could treat it as being still the principal residence, even though you had a child on title for an elderly parent, right? And that was the sole reason for it. So if you've got something that you can place reliance on, I don't think they should be able to come back and change their minds afterwards.
And you both have to declare, right, when you're doing
Yeah, you have to declare, yeah. Yeah?
I thought I read somewhere that the exemption for rental restrictions ended starting in 2020.
I don't recall that off the top. I can check that for you.
So if you have a
Yeah.
rental restriction, you're good forever?
Yeah, that's what the legislation initially had said, so I can go back and check that for you afterwards. Do you remember off the top, Alison?
I don't remember that,
Yeah.
no.
Well, thank you very much. Thank you all for coming on this miserable day too, and making your way down to through traffic to come and hear Alison and Pam speak. And you'll know why Alison teaches at Okanagan College as well, so you know why we're getting the benefit of all their expertise, and really appreciate them taking the time out to explain this. And I think all of these expert panel sessions, when I listen to them, I think this is why you hire experts, because it's so complicated. And it's always the unintended consequences of decisions that you've made along the way that you don't realize the impact. So I really think it's great. So let's give Pam and Alison a big round of applause. And happy holidays, everyone. And we'll see you next year.